So I believe that there is more to lawmaking than just passing bills. Certainly, Article 4, Section 1 of the California Constitution obviously grants the lawmaking power to our legislative branch of state government. Of course, they actually share it with the people through the forms of direct democracy, initiative, and referendum. Nonetheless, I think lawmaking does not mean just passing more bills and creating new laws. It also means oversight and accountability, and other things as well, such as constituent service. Now, this is not a partisan stance, and it doesn't matter who's in office in either the legislative or executive branches of California state government. Instead, I think it's based upon a strong belief that a key responsibility of the legislature itself is to evaluate existing laws and determine their effectiveness. This is especially true in tough budget times when the state really can't afford to be wasteful or duplicative in providing critical services. Now, while California continues to face a myriad of public policy issues that demand attention by the legislature, simply enacting additional laws may not always be the best answer. In addition to the need to provide oversight, alternative solutions should also be examined as part of the legislative process. What that means is that the legislature generally considers just the bills before them. Is this particular approach, as set forth in this bill, the best approach to solving the policy issue? The better approach is to consider alternatives before the decision is made to take a certain legislative route. In fact, legislation may not be the right response in every instance. But returning to oversight and accountability, this doesn't have to take on a partisan nature and does not have to be a showdown between the legislative and executive branches of state government. Instead, it should be viewed as a critical part of the legislative process, essentially a continuum from bringing forth a policy proposal through its eventual enactment and, of course, evaluating whether the law is working as intended. In this light, the legislative branch in California needs to ensure that after a law's enactment, that there's appropriate review and examination, which can be conducted by the more than 50 standing committees in the legislature that have jurisdictions over a myriad of policy issues. So, what do you think oversight and accountability look like in practice? I don't think anything new has to be created. There are already adequate procedures in effect that are available. For example, there are specific internal rules that apply to oversight hearings by the legislature, including the following. For example, Assembly Rule 11.5 provides that the standing committees of the Assembly, remember there are 32 of them, created pursuant to Rule 11, with the exception of the Rules Committee, are hereby constituted Assembly investigating committees, and they're authorized and directed to conduct oversight hearings and to ascertain, study, and analyze all facts relating to any subjects or matters which the Committee on Rules shall assign to them upon request of the Assembly or upon its own initiative. In addition, in Assembly Rule 11.5, Subdivision B, it also specifies that each of the Assembly investigating committees consists of the members of the Standing Committee on the same subject. And Subdivision D of Assembly Rule 11.5 notes that in order to prevent duplication and overlapping of studies between the various investigating committees created, a committee may not commence the study of any subject or matter not specifically authorized or assigned to it unless and until prior written approval has been obtained from the Committee on Rules. Now, Joint Rule 36 is also there, but first, Senate Rule 16 is quite similar to the Assembly rules, and it provides for general powers of standing committees, and it states that each standing committee of the Senate to which a proposed law or bill is assigned has full power and authority during the session of the legislature or during any recess to make an investigation and study concerning any proposed law or bill as the committee shall determine necessary to enable it to properly act. So let's turn over to the joint rules. In Joint Rule 36, it provides for investigating committees, and it specifically says that in order to expedite the work of the legislature, either house or both houses jointly may by resolution or statute provide for the appointment of committees to ascertain facts and to make recommendations as to any subject within the scope of legislative regulation or control. The resolution providing for the appointment of a committee pursuant to this rule shall state the purpose of the committee and the scope of the subject concerning which it is to act, and may authorize it to act either during sessions of the legislature or when authorization may lawfully be made, including after final adjournment. Additionally, there is Joint Rule 36 that says every department, commission, board, agency, officer, and employee of the state government, including the legislative council and the attorney general, and of every political subdivision, county, city, or public district in the state, shall give and furnish to these legislative committees and to their subcommittees upon request information, records, and documents as the committees deem necessary or proper for the achievement of the purposes for which each committee was created. Finally, there's Joint Rule 37 that provides for JLBC, or the Joint Legislative Budget Committee, and that the committee, with the permission of the appointing authorities of those two houses, may create subcommittees, assigning to the subcommittees any study, inquiry, investigation, or hearing that the committee itself has the authority to undertake or hold. So, as you've heard, there are numerous available processes for those 32 Assembly standing committees and the 23 Senate standing committees to investigate or hold oversight hearings on laws that are in effect and how they are being implemented and interpreted by the executive branch of government, for example.